Hello, and today I want to have a look at the classification of trust. So the legal notion of a trust we've already discussed in a previous video, and today I want to look at how we classify it. What I've done is I've created this little poster here whereby you can see how each different distinct type of trust fits in. And if you want, you can pause the video now to copy it down, but otherwise I'll be making reference to it throughout the whole video. So let's get started. The first thing to understand is that a trust can be created in two ways. It can be created expressly or non-expressly. And the non-express trusts are also called implied and imputed. So let's start with express trust because they're much more easier to understand. Essentially, what is the express trust? It's where the settlor expressly makes the declaration that there's going to be a trust, and he says that this is the trustee, either it'll be a third party or himself, and these are the beneficiaries. Simple. But an express trust is further divided. We don't usually just refer to trust as express. We usually refer to it as a fixed express or discretionary express trust. So what do I mean by these things? So in a fixed express trust is where the settlor expressly says that so there's a trust on this property and each beneficiary is entitled to XYZ benefits to the property. Whereas in a discretionary trust, what the settlor does is he leaves the entitlement of the beneficiaries up to the discretion of the trustees to decide how much each beneficiary is to get. So it's very simple and straightforward, and the courts prefer the express trust is because the settlor has showed a clarity and a certainty of intention that yes, I want to create a trust, this is how I'm going to do it. Either I'm going to say these are the beneficiaries, or the settlor will say no to the trustees, you are in charge of splitting the property between the beneficiaries X, Y, Z. It's fairly simple. Now, moving on to more complex grounds is you have the non-express trust, which, as I've said before, they're also called, sorry, let me fold this properly, implied or imputed trust. So let's try and get this all in. Okay, so the first separation in the non-express trusts are between constructive trust and resulting trust. Now, both are very similar, and like literally it's a nuance, it's a very subtle difference between the two, so it might take a bit of time to get your head around this, but it's not a problem. So a constructive trust is a trust created where the courts find it unconscionable for the legal owner to retain equitable ownership. So an example of this is where there's a trust property that's transferred to a third party who had knowledge that this was a trust property and there was beneficial interest. The courts will seek to imply a trust there, even if it's not been expressly declared, just because it wouldn't be fair. And so the idea of a constructive trust is that courts construct a trust because they want to satisfy the demands of justice, good conscience, and equity. Now, before I talk about the separation of constructive trust, let me just briefly go on to resulting trusts and how they differ. Now, resulting trust, the focus is that it's a trust created by operation of law, as opposed to the courts having the discretion of trying to satisfy the needs and the demands of justice and good conscience, and what is right is right. In resulting trust, it's to do with the operation of law, and there's two specific situations where they arise, and we'll talk about that in a minute. But let's go back to constructive trust. Now, in constructive trust, you can further divide them. You can have an institutional constructive trust or a remedial constructive trust. So what do these things mean? Well, the remedial constructive trust is mainly what is used in the US trust model, and it's basically the trust structure is thrown upon a situation because they're trying to resolve some kind of injustice that has been done. And just before I move on to institutional constructive trust, the idea is that the discretion, it's in the discretion of the courts to decide where it would be fair to imply it. Whereas an institutional constructive trust, this is like the traditional old English model, which is that, well, we don't care whether there's injustice or these people have suffered. It's if the conditions are satisfied, we will impose a trust. So it's regardless of any injustices that's happened. It's not looking to remedy any kind of situation. It's just, this looks like a trust, so it is a trust. We're not looking at anything else. And so they both are constructive trust because they both are, looking at goodwill, equity, and justice. That's the reason why they're imposed. One is just imposed because, in law, in the institutional framework, we say that these things are there to uphold justice. Therefore, we impose a trust. Whereas with the remedial side, there's some kind of injustice, and this is why, we're going to impose it. And another key distinction is, as I mentioned, with the remedial trust, it lies within the discretion of court, whereas institutional constructive trust, they imply that the rule of law is what's implying them, as opposed to the courts having any discretion whatsoever. Now, if we look at resulting trust, now this is similar, remember the boundaries aren't quite clear, it's similar to the institutional constructive trust, that again, we're looking at the operation of law. But it's different to when we're looking at constructive trust, is because Lord Brown-Wilkinson in the West Deutsche Landsbank and Islington London Borough Council 1996, he says there's two specific situations where resulting trusts arise. Resulting trusts being trusts that arrive by operation of law, and those are automatic and presumed. Automatic resulting trust is essentially where there's been an attempt to create a trust, but the beneficial interest fails, or the beneficial interest hasn't been fully dealt with, therefore fails, and therefore automatically there is a kind of resulting trust because the equitable interest does go somewhere else. The other situation is the presumed resulting trust. This is where voluntary gifts are made, i.e. property is transferred for no consideration, or somebody has contributed to the purchase price. Here, what the idea of a resulting trust is that equitable interest results back to the person who's given the free gift, or the person who's contributed to the purchase price. So it's not looking at goodwill and justice, because these are operations of law, i.e. there's an issue with the beneficiary in the automatic case, or in the presumption case, there's a voluntary gift, there's no consideration, or somebody has contributed to the purchase price. Whereas constructive, even if you're looking and saying, well, it satisfies, the legal conditions for a trust, therefore an institutional constructive trust does exist, you're doing it from the perspective of there being some kind of goodwill and justice reason behind it. Sorry, this is such a long video. I hope this helps. Please visit my website.